a second round
Senator
of questions?
Klobuchar, I allowed you to go way over your time in order to make up, and I wrote it down.
Are we having a second round?
No, ma'am. I just wanted to let you know that I did give you extra time and over what was taken up.
Okay,
So thank you so much.
okay.
I appreciate it.
Okay, a lot of times when senators are still here and there is no one else here, they let them have a second round?
Absolutely. I'd just like one moment to ask about an issue that
Okay,
came
well, you
up
should, yes.
that is regarding TROs. And I just want to make sure that the committee as a whole has an understanding of TROs, how they are used, so that they can take this into account in the proposed legislation. TROs have been used historically by judges, and they haven't been immediately appealable. And it is in the proposed legislation that we change that practice through law and make sure that TROs are appealable. Do you think that would remedy some of what is happening today and some of the distrust that certain judges are making partisan rulings? Mr. Panuccio.
Thank you, Senator Moody. I do think that when a TRO, well, let me step back. TROs now are starting to look a lot like preliminary injunctions, and preliminary injunctions are immediately appealable. And so it really shouldn't matter what label the court puts on it, whether they call it an administrative stay, a TRO, or a preliminary injunction. If the court is enjoining preliminarily, before a party has proven, before a jury or a judge, entitlement to relief, if they're getting that injunction, it should be immediately appealable, no matter what the label is.
And that would make a significant change in court procedure in comparison to how it's been applied historically.
It would. There is some very recent scholarship out about how exactly it came to be that TROs are not appealable. But given what's happening, yes, legislation to address it would probably be the most expeditious way.
So that seeks to expedite review of some of these cases where judges are issuing nationwide orders. And I want to go back to something that we've heard pretty much on both sides of the aisle today, questions pertaining to executive authority, Article 2 authority, and whether or not that should even be reviewable in some instances, especially as it relates to national security matters. Are there instances to alleviate partisan concerns? And I'm sure as a lawyer, it causes you great concern for the stability of this nation and our separation of powers, that there would be a suspicion of partisan agendas among our judges. That's concerning, correct?
We want our judges to be seen as nonpartisan and applying the rule of law only.
And would there be an instance where utilizing a 3-judge panel might alleviate those concerns?
Thank you, Senator. We have instances of that. There are numerous different kinds of cases where a 3-judge panel, the statutes require that a 3-judge panel is convened, and sometimes it is because the cases are of significant national importance or have some kind of, I don't want to say partisan, but important valence to them in terms of the policy. So we see this in redistricting cases, for example. There are 3-judge panels. So there is a place for 3-judge panels, I think. I will say that I personally don't believe that we should say if someone seeks a nationwide injunction or non-party relief, it goes to a 3-judge panel, because that would give the imprimatur of validity to non-party injunctions. And I don't think they're valid if 1 district judge does it, or 3 or 17. I don't think district courts have that power.
But certainly in some instances that might be indicative that the public may prefer a 3-judge panel for assurance of impartiality, that might be preferable.
Right, or another way to put it is just to make sure that there is greater deliberation among intelligent judicial minds about major issues. So, for example, you could have, in substantive areas, you could say, look, if it's a case about the president's wartime powers, it's not going to go to a single district judge. It's going to go to 3 judges, because we'll get the benefit of 3 times the benefit of judicial reasoning.
And even if there were a 3-judge panel, the need for expeditious review would still be important if it is a matter of great national concern or interest.
I think expeditious appellate review of cases implicating policies of significant national concern is important.
Senator Brett.
Thank you, Madam Chairwoman. Want to go ahead and jump in. I know that you've talked about a lot of the issues that I wanted to bring up, but Professor Bray and Mr.